Good morning. Well, it's the beginning of week 7, the next to last week of our course, and a very important week for a couple of reasons. First, we're going to take a little detour away from the criminal side of things to do a very short course in civil litigation. Please know, as we're going through this week's material, that all of the material has compressed what would be in law school perhaps 4 semesters worth of work into 1 week. So we have greatly simplified the whole civil side of the courts, but that's okay because this course is primarily one that deals with criminal prosecutions, as you know. Another very important thing that's happening this week, and I'm sure you're aware of this, is that your final projects are due. Now, please keep in mind, this is not the last week of the course, but this is the week in which your final project is due. Know as you are preparing the final project that you've probably already done almost all the work that's needed to put that project together, because really it's a compilation or culmination of the 2 milestones that you've already written and also the short papers that you've already written. The information, in other words, is stuff that you've already gathered. Now you just need to put it together in the final form of the project. And the best way to do that is to have the final project grading rubric in front of you as you're preparing that final submission, to make sure that you don't leave out any aspect of that final assignment, because it is a very large part of your final grade, and I want you all to do as well as possible, and I'm sure you want that too. Well, now let me get into the civil side of things a little bit and discuss what you're going to be reading about this week. First, when you switch from criminal to civil sides in the court, you are changing not only the goal of what you're doing, but also the terminology. The parties in a civil suit are called the plaintiff, that's the person who brings a civil case, and confusingly, the person against whom that case is brought is called the defendant. Obviously, you know the word defendant because that's also the person against whom a criminal case is brought. Don't let that terminology confuse you too much. There's a lot of redundancy in legal terminology, and we just have to live with it and learn to distinguish a civil defendant from a criminal defendant. In a civil suit, not only are the words different and the parties going by different names, but also the goal, and this is the most important thing. The goal of a civil suit is very different from the goal of a criminal prosecution. In a criminal case, the goal for the state is to punish the defendant for having broken the laws against the people of the state or of the federal government, if it's a federal prosecution. In a civil case, you have 2 individual parties, non-governmental entities, that have a difficulty with each other, a problem with each other that they haven't been able to resolve. And so they've turned to the court system to help them resolve that difficulty. And what they're seeking, what the plaintiff is seeking, not the defendant, but what the plaintiff is seeking is compensation for injuries that the plaintiff says were caused by the defendant. Well, the plaintiff can't just come into court and say that the defendant has caused an injury of some kind, and that injury can be a physical injury, it can be damage to property, it can be mental anguish, it can be the loss of a job, it can be any number of things that are considered to be civil wrongs, breaches of contract, torts, manufacturer's liability. There's a plethora of reasons why civil suits can be filed. But the goal of every civil suit is very similar, and that is, as I said, to compensate the plaintiff for damages caused by the defendant. Now, if, let's say that you have a case in which the plaintiff's arm has been, and this is extreme, the plaintiff's arm has been severed by the defendant. Well, the compensation for that can't be a new arm. I mean, that's impossible. You can't just wave a wand and have the arm come back. So the law provides not for actual putting the plaintiff back in the same position that he or she would have been in had the injury not occurred, but instead a way of measuring that injury in terms of dollar amount. So that instead of getting a new arm, the plaintiff's goal would be to be compensated in money by the defendant in an amount equivalent to what the loss of the arm has cost the plaintiff. In other words, the law in a civil suit tries to put a dollar value on whatever it is that the plaintiff has suffered. Now, obviously, that is a difficult thing to do, and that's why we have juries. That's why we have zillions of laws and regulations and precedential cases that guide courts and juries in terms of awarding or not awarding compensation in a civil case. We're not going to get into that this week because it's far too complicated. We are going to skim the surface of civil procedure a little bit. One other major difference between a civil suit, and this comes in at trial, and a criminal prosecution is the standard of proof that the plaintiff has to meet in order to win a civil suit. As you know, in a criminal prosecution, the prosecution has to prove the defendant's guilt beyond a reasonable doubt in order to get a guilty verdict. In a civil suit, the plaintiff has to prove by a preponderance of the evidence that the defendant caused the plaintiff's injury. Now, preponderance of the evidence means that the plaintiff has to prove that it was more likely than not, that the defendant caused the plaintiff's injury. As you can tell, that's a far lower standard of proof, far lower bar to jump over than the criminal standard of proof beyond a reasonable doubt. You will see as you read the materials in this course, and probably just as you live your lives, that the civil standard of proof is, although it's easier to reach, is not necessarily a very easy thing to do. There are lots of barriers that the defendant will put up along the way that will keep the plaintiff from winning, and that's as it should be. This is a civil suit is a way for the plaintiff and the defendant to sort of duke it out in the courtroom instead of in a more physical way. To resolve their differences, in other words, as civilized people in accordance with the law, instead of taking matters into their own hands. That's the whole basis of theory behind the civil litigation system. Now, you're also going to be talking or discussing and also reading about the scheduling and docketing and procedural elements of civil litigation and how they are similar to criminal litigation and how they differ. The most important thing we're going to consider, at least the thing we're going to consider most in depth, is discovery. Discovery, as you know, is the pre-trial activity in which the parties try to gather as much information about the case as they can to support their points of view with evidence at trial. Discovery has that same goal in a civil case, and in many states and sometimes in federal cases, the discovery process seems endless, honestly. I mean, it goes on and on and on and on, and the result of that is not only the prodigious accumulation of evidence, which is good, but also the putting off and putting off and putting off of trial. If you read the literature, you will see that more than 85% of all civil cases filed in the United States are in fact settled out of court. Hardly any of them ever go to trial. And that percentage, by the way, is growing every year for many, many reasons, one of which is that the cost of a civil trial is skyrocketing. I mean, really, it is nearly unbearable for all but the most wealthy of parties. But again, I wish we had more time to discuss this in this course, but we don't. So we'll have to compress our consideration of civil litigation into just the surface, as I said. And if you have any questions that go into more depth about civil litigation, or that go into more depth about discovery or anything else that we are talking about in this course, please always ask them either in the general discussion board, or in the discussion board on discovery, or just in an email to me, or however you wish to communicate your question, and I'll be more than happy to address it. Let me just say also that civil litigation is usually an activity that occurs between two people who, in theory, not always in practice, but in theory, are roughly of equal stature. That makes civil litigation worlds apart from criminal prosecution. In criminal prosecution, you have the full power and authority of the state coming down against a tiny little individual criminal defendant. And it doesn't always look like this David and Goliath kind of contest, but in fact it really is, because when you have the full power of the state being mustered against a criminal defendant, you have a built-in inequality. In civil litigation, that's not the case. You have two parties who, under the law, are equal. In criminal prosecutions, because of that inequality, as you have seen in our previous weeks, the law bends over backward to protect the defendant, to provide counsel, to provide a speedy trial, to provide a jury trial, to provide the requirement of warrants for searches and seizures, to provide all sorts of protections for the defendant. And the reason for that is because the defendant is a tiny little individual with no power versus the state, which has enormous power. As I just said twice, and I will say now a third time, that's not the case in a civil suit. In a civil suit, you don't have that built-in protection for either the plaintiff or the defendant. They come to the court on equal terms. So they usually have the same discovery requirements of the plaintiff and the defendant. Each has the same discovery rights and requirements and responsibilities. Each has the same evidentiary rights and responsibilities. So it's a very, very different animal, civil litigation. But we will zip through it this week. I hope it will interest all of you enough that you will perhaps study it in more depth in other courses or later in your life just for fun. I also really hope that you never have to experience it personally, because it can't be very pleasant. But still, it's a good tool there that is the law provides for all of us to redress grievances that we can't resolve on our own. I'm going to be quiet now because this video is a little bit longer than I usually go, but please do ask me any questions that you may have this week, and remember to get those final projects in. And as you are compiling your final project, if you have questions about how to approach it, if you have questions about form or substance, I'm here to answer those questions for you. Good luck. Bye.